On this 7th day of November 2024, welcome to the third hour of Kenya's biggest conversation. It's a Situation Room with Eric Latif Nduoko, CT Muga. CT, there are several universities in Ireland.
Yes.
Just mention a few, and those that will be participating in this Saturday's Study in Ireland Fair.
Griffith College, University.
Griffith College.
Galway, University, who's favorite? University of Limerick, Dublin City University, Technological University of the Shannon, Independent College, University College Cork.
Okay.
Yes.
Izo zote.
Izo zote.
Very good. And now, what we are saying is that this Saturday from 9 a.m. to 1 p.m., the representatives from these universities will be at the Gallant Mall in Parklands.
Yes.
Right? For the Study in Ireland Fair. How do you register to attend it?
Well, you simply need to go to www.cradle.com.
Cradle.com.
That's it.
That's it.
That gives you the gateway to registering, because entry to this particular fair is by invitation only.
Fantastic.
And to get the invitation, you need to register.
Fantastic.
Yes.
Fantastic. Ndu. So if you're thinking about banking and you want, to live the soft life
Yes.
with banking, no stress in this world, where do you go?
You go to Stanbic. It's Kenya's #1 private bank. We looked at banking easily. We looked at banking joyfully. And now, today, because of Stanbic, we're looking at leaving a legacy. What are the different things that you can do? There is wealth management expertise up for grabs for you, in-depth investment insights. That's what we talk about, leaving a legacy, isn't it? That you can put your money in a place where it can actually give you something to bank on. See? In the future. Local and offshore investment opportunities, equities and bonds online trading, diversifying your portfolio, not just putting all your eggs in one basket, literally, but then being able to show you the different places that you can put your money and actually grow your wealth. Also, talking about competitive saving and deposit rates. These are all the things that Stanbic has to offer for you and can be done for you in a place of comfortability. There is no better time than to get in touch with Kenya's #1 private bank so that you can leave a legacy.
Yeah. Keep listening to us. We'll tell you how you can win 25,000 shillings into your Stanbic account. And we'll be telling you about that in coming days. Now, we saw just this week the Supreme Court of the Republic of Kenya was marking 12 years since it was first established. So the Constitution says we have a judiciary. It's going to be a robust judiciary, and the apex court in Kenya is going to be the Supreme Court. And it even says how many judges sit in the Supreme Court, and says the leadership of the Supreme Court. The president of the Supreme Court shall be the Chief Justice of the Republic of Kenya, who is the head of the judiciary, who also heads very many things: the chair of the Judicial Service Commission, the chair of the National Council on Administration of Justice, the chair of very many things. The current Chief Justice is Her Ladyship Martha Koome, and she's our guest. Good morning, Chief Justice.
Good morning, Latif.
Welcome back to the hot seat of the Situation Room.
Thank you for having me.
It's been a while. We cooled it down for you.
I don't know whether you cooled it down or you heated it for me.
Karibu sana.
Asante
It's
sana.
good to see you. And as we're going to talk about the Supreme Court and the 12 years of the Supreme Court, what it has achieved. Is it defending the Constitution? What's it meant to do? And is it doing exactly that? But first, CT will welcome you with the day's proverb. This week, he's in countries south of the Sahara.
Yes,
Uh-huh.
I am.
Yeah.
And the specific country that we are mining proverbs from is the Democratic Republic of
Congo.
Yes, I was going to say du Congo, because that is the French way of looking at it. DRC. Yes. A very populous country. 109 million people.
Wow.
And counting.
As at the last count.
Yes. They have lost very many of their citizens due to wars. The last one cost them 5.4 million people died. That's how terrible wars can be. The proverb: a message from a dead man is poison for the one who doesn't respect it. A message from a dead man is poison for the one who doesn't respect it.
Madam CJ, what do you think this proverb is saying?
It sounds like a curse.
You think so?
Yes, it does. Yes, it does. But
So what's the lesson here? A message from a dead man.
Is poison,
Poison.
To one who doesn't respect it.
Yeah.
Yes, which means we must always respect what the dead have said. Otherwise, it becomes a curse. But that's a tough country.
Yes, it is. Yes, it is. Yes, it is. You see, if we talk about, for instance, the constitution we currently have, in 30 years from now, we'll still have this constitution may have been changed. The people who are behind that constitution will be dead. Now, those dead people spoke that constitution and they ushered it in. And for a very good reason. To understand it better, just look at the Americans who just had an election. And they have a constitution we keep talking about. The people who crafted it and started that constitution are all dead. But the constitution
Is alive.
It's alive.
precisely is a living
And speaking.
document.
And it's
speaking. Now, if you ignore what it is telling you, bas.
Risha.
And that's where you're right. It becomes like a
A
curse.
curse.
CJ, the Constitution of Kenya establishes the Supreme Court of Kenya, right? What is the job that the Supreme Court is given by the Constitution?
It is clearly set out in the Constitution. The Supreme Court is the apex court in the sense that it determines certain matters that are defined in the Constitution to their logical conclusion, brings them to a logical conclusion. The presidential election dispute, appeals that involve the interpretation and application of the Constitution, matters that have been certified as raising general public interests, and issues to do with devolution, especially advisory opinions that are brought to the Supreme Court. So those are the jurisdictions that are given by the Constitution to the Supreme Court, including, of course, an appeal arising out of a decision of a tribunal to remove a judge. And one jurisdiction we have never exercised to determine whether there is a state of emergency, a declaration of state of emergency.
Okay.
Yes.
Now, if we look at all those,
Yeah.
would you say that in the last 12 years, the public has understood the job of the Supreme Court of Kenya?
That's work in progress because the population is transient in the sense that the people who made the Constitution, many of them maybe have transitioned. We have young people who are children when the Constitution was promulgated about 14 years ago. Those who are teenagers now are adults. We have others who are not born, but they are born. They are 14 years. So it's a continuous process of engagement to let Kenyans know what the Constitution says, the institutions that have been created by the Constitution to serve the people, the institutions that have been given power, the sovereign power of the people to serve the people. So it's a continuous engagement, and that is why we felt it was necessary for the Supreme Court to celebrate 12 years so that we can introspect and we can reflect together with Kenyans to see what it is that the Supreme Court has done in the last 12 years, shaping jurisprudence, determining complex issues that bring stability in the law, in the economic setup, in the land issues, in the human rights, in the political landscape. So we have had that conversation involving stakeholders, scholars, lawyers, experts, other jurists, judges, chief justices from other jurisdictions. We had 6 chief justices attend the conference, and I think one of them, the Chief Justice of Liberia, was your honored guest.
Yep.
So it was a very deep conversation to let Kenyans know what the Supreme Court does, because sometimes we are mistaken that we are only seen after 5 years to determine the presidential election dispute. We disappear to nowhere, and then we appear again after 5 years. That's not the case. We are busy throughout the year.
You know, the journey to the 2010 Constitution had very many aspects into it. One of the strongest ones was the fact that the Independence Constitution had been amended so many times. In fact, people had said it had been mutilated. And there are those that say that by establishing the Supreme Court and giving it specifically that mandate to interpret the Constitution, this was the body that was given the job of defending the Constitution, not just the letter of the Constitution, but also the spirit of the Constitution. Has it done that?
We have done that superbly, even according to the verdict of the stakeholders who attended the conference, and they examined deeply the jurisprudence that has been churned by the Supreme Court. The leading case in constitutional reform or amendments is the building bridges case, which is still fresh in our minds. You remember there was an attempt, probably by the political class, to amend the Constitution through major amendments of almost over 70 articles were being affected by that move to actually overhaul the Constitution. And you remember the Supreme Court handled that matter, and with the finality brought to an end that attempt to mutilate the Constitution, and even to bring other ways of amending the Constitution which had been proposed, which was being borrowed from other jurisdictions. We were able to examine our Constitution, and they saw that it has an inbuilt system of amendment, and we did not have to bring other theories from other countries to see how to amend our Constitution. It is self-sufficient. If you want to amend it, you just turn into Article 255, 256, and 257. And perhaps what we recommended was that Parliament should enact a law that guides amendment of the Constitution. Much the same way we are in the CKERC when we were amending this Constitution, and we developed even rules and regulations that guided every other step so that there are no missteps in between, and Kenyans are aware what steps to take if they want to amend the Constitution.
Madam CJ, over the last couple of days, and I think even easily for the last couple of years, when decisions of the court, the Supreme Court, have been made, that what is taken into consideration is jurisprudence. It is the rule of law that is taken into consideration over and above everything else. It is interesting because in conversations with some of the members of the Supreme Court, and I believe one in particular said that, also what is taken into consideration is the prevailing circumstances in country at the time. And how would you say that the Supreme Court has dealt over the past few years? What has been taken into consideration with a number of the rulings that have been made, decisions that have been taken? Is it the rule of law? Or is it the atmosphere in the country, or is there a balance between the two?
The most fundamental consideration and the most central is the rule of law. Because the rule of law is the foundation of everything. Is the foundation of the peace, the tranquility, basically the business. It is the rule of law that is known by everybody. And that is the one that is written, and that is the one that governs the country. So every decision of the Supreme Court is predicated on the rule of law, principally the Constitution. What does the Constitution direct and dictate. Then we go to statutory laws. What does the particular statutory law provide? Then within that context, there is also the social context of what is happening. That may have an influence here and there, but majorly is the rule of law, is the interpretation and application of the Constitution, which we cannot remove and which cannot be overtaken by the social context. Whatever is happening in the social context must be premised, must be predicated on the rule of law, because the rule of law is the one that cuts across everybody. Yeah.
What's the process of decision making in the Supreme Court? You're 7 judges, right? So a matter is brought before you, all arguments are brought before you, and then you say, now the court shall retreat to render its decision. What happens at that point? How do you go about that?
Every individual judge has to read the file. If we are sitting 7 of us, the quorum of the court is 5. In the random dairy matters, we deal with 5, a bench of 5. But matters that are bearing significantly to the larger public, general public, the matters affecting the nation, we all sit 7 of us. And it's very, very difficult because, that is a very small bench. Doesn't allow a lot of latitude. We wish we were 11, where we could have 2 benches sitting and the CJ being a little released to deal with the Judicial Service Commission and other obligations. I have almost 67 statutory duties to perform under our laws. So it's a very busy office, and being the head of the institution, the administrative end of the institution, you also deal with so many administrative issues. But there we are, 7 of us. So each one of us read the file. We also research on the issues that have been raised in the file before the hearing, because we have a team of law clerks who assist us with the research. So they prepare what we call bench memos for each of the justices that summarizes the case, that puts together the issues. But we read ourselves, and then we have a conference before the hearing of the matter.
Madam CJ. So each judge will have their own set of researchers who will give them their memo.
Yes.
And the memo from researcher A to Judge A may not necessarily be the same, the memo that goes to Judge B.
It may not, because these are different people.
Okay.
Perceiving the matter differently. They are lawyers also. Some of them are quite senior, over 10 years experience.
Okay.
So before we go to the hearing, we conference. Then we go to the hearing, we hear the matter. Like now, we have been doing it virtually. And the Supreme Court is by way of submissions where counsel or the parties will highlight the issues. So after the hearing, we retreat again for another conference. And sometimes we may conference for days. So it's through the conferencing that we look at the various scenarios, various understandings, various research. We look at the law, and then we agree. Are we agreeing on issue number 1? And all of us will say whether we agree. Issue number 2, issue number 3. If we agree on all of them, then we can have one judgment. But there are times when some of us will say, I agree, but my reasoning is different.
Right.
But the outcome is the same. That's what we call concurrence. Then we'll have a dissent, somebody who feels that they have a divergent of opinion, and then they can write a dissent, perhaps not on all the issues, but on the particular issue they dissent on. We were asked, how come we are having unanimous decisions? We tried to write separate judgments during the BBI, and the judgment of the Supreme Court, you can check it, is over 1,000 pages. It's very difficult to read because, 150 pages, 200 pages for each judge. So therefore, if we are unanimous, then, and it's very difficult also because each one of us has to read those 7 opinions. And it takes a lot of time. It can take a year, by the time you read the 7 of them, by the time you see now, like when you're making the final orders, who is agreeing and who is disagreeing, who is dissenting and who is concurring. So the BBI decision taught us a lesson that, unless it's absolutely necessary, if we have agreed on the issues, then we can have one composite judgment. It is easier to follow as a president. It's easier also for the students who follow our judgments. It's easier for the citizenry. It's easier to summarize it and give a media summary.
So in this conferencing, when you do it, how is it? Is it a debate? Do you debate? Or does a judge come and say, this is my thinking about this particular issue, number 1. This is why I think I disagree. And then all of you say, we respect your opinion. Okay. Judge number 2, what do you think, Honorable Justice, or so and so? Is that how you do it?
It's the way we do it. It's like you have been to our conference. We do it in a very orderly, systematic manner.
There's no debate. There's nothing
we
like
begin.
Judge A,
what do you feel? What is your view on this matter? So Judge A will explain. I've listened, I have read, I have reflected, and this is what I think. Then go on and say their position. Therefore, I come to the conclusion that this appeal should be dismissed for the reasons that I have given, or this appeal should be around. Then you go to Judge B all the way until now the Chief Justice. I'm always the last to speak. Then, of course, from the conversation, you know whether the appeal is being around or dismissed. I also have my view. Is it going to be around or is it going to be dismissed? And I say my view.
So what's the point of conferencing then?
That's conferencing.
So there's no point for one judge to try and convince the others?
They do.
Is there a point where
they
judge
do?
Judge
because
5,
out of those issues,
right,
they will say, for me, I think this appeal is for dismissal. Whereas the other 4 or 5 are thinking this appeal is for allowing. So then that is the point of very serious debates.
I see.
Yes.
I see.
Yes.
The reason I'm asking
And
this,
we may not even end up there. We may adjourn to go and do further research, say do more research on this area. So we need another focused discussion on the area of discussion. We come back for another discussion. Like for BPI, we conference for 2 weeks.
I see. The reason I'm asking that is because, of course, what's in the public domain is how do they arrive at the decisions that they arrive at, right? And are they protecting the Constitution or are they protecting other interests? Or is there influence that comes to the judges in between the entire process of hearing a matter up to the point of making a decision? Is there room for external influence into the decision of even as an individual judge? Is there room for such?
You know, Ratif, you can only ask me whether there has been external influence over me. What happens to other people, you may not know. Would I know what's happening to you, Ratif, in your house, in your private spaces?
Well,
I wouldn't know, but as president,
Yeah,
we expect you to know.
because I have 7 times 2 eyes to
Yes.
see.
We don't care how many you get.
Yeah, it's very, very difficult.
The public expectation
It's
is that
no,
President of
let
the
me
Supreme
speak for
Court-
myself. Nobody has ever tried to influence me as a trial judge, as a judge of the appeal, as a Supreme Court judge, and as the president of the Supreme Court. because I cannot allow, the Constitution does not allow us to be influenced by anybody or any authority. So whoever would be attempting to influence me, I would quickly refer them to the Constitution because it's written there in black and white.
Would you make it public?
But I'm making it public.
If somebody did try to.
I would.
Okay.
I would. And what I would do, like during trial, when I was a trial judge, because you'll be approached through maybe the church, through your merry-go-round women group, and they don't do it directly. What I did was to declare immediately that this is not a position where you can be approached. And if you did approach me, the thing I'll do is expose you, and I will also recuse myself from hearing the matter. So nobody approached me. And I told all my associates, my relatives, my friends, that if you ever speak to me about a case, that is going to be the end of our friendship. Because our friendship is not predicated on my work. My work is separate.
Being your friend is difficult. Huh?
It is. We have just to talk about friendship. Our children, we reminisce of our old days. We reminisce over the nice things we like to do together. It's not predicated on favoring them with a judgment.
If somebody has...
And it cannot be favor. You cannot favor anybody.
We're going on to a break, are we?
Let's take a break.
Okay.
Titi. Let's take a break,
Yes.
right? And then continue this conversation. As we take a break, remind everybody why Tala is important
Well,
as a companion.
Well, it is important because Tala speaks, acts, and functions, and is about money. And we all understand what money does. For us, we all understand how we relate to money. Whether it is something that you want to do and you've planned for, or whether it's an emergency. Tala makes it possible for all these things to happen. Now, all you need to do is go to Google Play and download Tala. When you download Tala, they will provide you with information that you will find suits your needs. So in the event of you requiring money for whatever it is that people require money for, let me repeat, be it an emergency, be it something that is business related, something you do on a daily basis, Tala becomes a trusted friend who will come to you at the time of that specific need.
You're right.
Yes.
Time for that break, 24 minutes to 9. Our guest today is the Honorable Chief Justice Martha Koome, Chief Justice of the 15th Chief Justice of the Republic and President of the Supreme Court, among very many other things. We are talking about the Supreme Court today as it commemorates 12 years since the establishment of this Supreme Court.
This is the Situation Room. When I have back pain, I reach for 2 tablets of Panadol Extra.